Okay, Chuck. So why don't we start by just giving a bit of an introduction? Who are you? What is and who is Osuji and Smith? Just a very brief intro.
Okay, first of all, Drew, it's good to see you again.
You as well, pal.
Well, my name is Chuck Demiri. I'm a senior associate with Osuji and Smith Lawyers. Osuji and Smith Lawyers is probably the biggest black-owned law firm right now in Canada. And the exciting thing about Osuji and Smith is that we are also dedicated to giving opportunities to foreign trained individuals, foreign trained lawyers, opportunities to come to Canada, to come to Alberta, to article, to through our Foot in the Door initiative, which is an initiative that was brought on board by the managing partner, Charles Osuji, also a foreigner himself.
Yeah.
He went through the crucibles of getting to get to practice law in Alberta.
Yeah.
And so when he established this place, he decided that some of the headaches, that face foreign trained lawyers,
Yeah.
that he would try his best to alleviate some of those headaches. So I think I appreciate him for that. And that's one of the reasons I came to Osuji and Smith, the kindness, the compassionate nature of this man called Charles Osuji. So we are a general law firm. We deal with all aspects of practice. Okay, and one of the unique things about us is that we try to ensure that we leave smiles on the faces of our clients.
Yeah.
Yeah.
Well, I mean, I've been a client for a long time.
That's good.
I know Charles from way back in the day. So you're absolutely right. Certainly an upgrade on the office
Yes.
from what I remember.
We used to be in Kensington.
Well,
We
yeah,
are, we are
that's
still there, right?
yeah.
But then we got this place, this very unique. I always call it a palace, Osuji and Smith Palace.
Palace. Yeah.
Yeah.
Just out of curiosity, what are some of the major headaches or barriers for foreign trained lawyers immigrating into Canada that Charles and you guys have tried or are solving?
Well, and I will give you an example with my own experience,
Yeah.
right? When I came into Canada, and again, the Canadian law space is such that, even if you went to Harvard, right, if you came into Canada, you must start afresh. That's the very unique thing about this country, right?
Yeah.
They want you to show them that you know what you're talking about.
Yeah.
All right. And that journey is not an easy one. It takes a while. Okay.
Yeah.
And so in the course of that journey, you need to be able to find law firms that can help you, keep you within the legal space.
Yeah.
All right. And that was, for example, one of the greatest challenges I had. I couldn't find such a thing. So Drew, when I came, I started by working at the Home Depot.
Yeah.
Right? So
Yeah.
I worked in the Home Depot for 3 years, taking my exams. And in that 3 years, I wasn't within the legal community. So you can imagine how difficult it was for me. Those are parts of the things that Charles Osuji, by establishing feeding, is trying to remove. I look at our volunteers here in feeding, and I am so, well, let me use the word jealous of them, right?
Yeah.
Because, on a daily basis, and, when they come, we involve them in all aspects of practice, from meeting the client, having a consult with the client, them developing the notes, getting them to do the work, getting them to do the research. In fact, before you know it, Drew, you yourself are feeling like a Canadian lawyer.
Yeah.
So when you are then going to face the exams, when you're going to face the articles, when you're going to face the CPLED exams, I'm telling you, you are fired up.
You're prepared.
Yes.
Yeah.
And you know why? Because the questions on the paper, all they're asking you is, what have you been seeing in the law firm?
Yeah.
That's all.
Yeah.
So that is a huge thing that Charles Osuji, by establishing feeding, Foot in the Door initiative, that is the very huge thing, the very huge mountain of of, of a challenge that he has removed. And I'm telling you, it is so beautiful. You know, my appreciation of Charles Osuji is not even because of the person he is. It is that he is not thinking of himself. He is thinking of the other person.
Yeah.
He's thinking of, he's like, love your neighbor like you love yourself.
Yeah.
Charles loves his neighbor more than he loves himself.
Good. It's a good philosophy that pays, right? It has returns to it. More ways than one, right?
Yeah.
It's interesting too, because just on that note, it has to be empowering in a multitude of ways, right? Like you now get exposure right away. You're like you obviously got into law for a reason, so you're passionate about that. So to come to Canada and have to work at Home Depot just must be
it was
hard mentally.
Yes, but I also am grateful for my experience at the Home Depot, and I'm not trying to in any way reduce the value of that experience to me. All right, or to my life, or to letting me know what living and existing in Canada is all about. Right?
No, absolutely not. Right? It doesn't. You're right. It's not meant to knock the experience, but you came here wanting to express and show a skill set that you had, right? So it's nice that you've now got a pathway to do that.
Do you know that a lot of our volunteers, when they are applying to other law firms, you know, to be picked or chosen for articles, once they see that you volunteered at Osuji and Smith Lawyers, oh man, that is like 70% of your acceptance.
Comes with a lot of credibility.
Right.
That's good.
Right.
That's good.
Right.
You know, just tangentially, right? So I, in a former life, I was a nurse, right? I was an emerge nurse.
Oh wow!
And it was a tough time for a handful of colleagues of mine because there's similar people that were in the exact same spot, just in that profession, right? Like I had a gentleman who was a good friend. Immigrating into Canada, was a cardiologist in his home country, and had a tough time even getting into a nursing program here. So anything that helps establish sort of a better bridging program, so that anybody from outside of the country can utilize their skills, I think is a huge asset and benefit.
Very huge asset. Very huge.
So, okay, well, we've got a slew of questions to go through.
Okay.
And I was thinking, why don't we start on the real estate side of things that sort of works well with a number of the clients that I've got, and we can kind of transition from there.
Okay.
But what types of legal issues do real estate lawyers typically handle?
Well, so first of all, you want to be sure that when your client approaches you, a real estate transaction, okay, you want to look at the documents that come with that transaction. You want to look at the contract. You want to look at the terms of the contract. You want to look at whether this individual has qualified for financing. You want to look at when the lawyer on the other side writes to you, are there trust conditions attached to the documents that are being sent to you? For example, there might be an inspection of the property, okay, and this hasn't been done or that hasn't been done. There is what we call holdback, right? And so a holdback is the other lawyer saying, look, this hasn't been done and that hasn't been done, okay? We would want you to hold back $10,000, for example, for the repair of such a thing, okay? And so we are going to release the funds to you on the trust condition that you do that holdback, okay? And so, and of course, the lawyer would say, if you're not able to meet with these trust conditions, please either keep those documents with you and do not do anything with them, all right? And then you find situations also where, and this happens to be true, right? We went and inspected the property we were to live in. And, one of the floors, a part of the floor, they had put a rug over it. Okay, and
Okay.
and
I
so
know where this is going.
yes, and so they had put a rug over some damage on the floor, right? So we inspected the property, and it looked okay, right? It looked beautiful and everything, and then we signed everything and stuff like that. And so when we now got professional cleaners to clean out the place, one of them pulled off the rug, and there was this great damage. But by then we had signed documents. We had, money had exchanged hands and stuff like that. Okay? So we had to start going through the process. And this is what I always advise my clients. Before you call Chuck and say, oh, Chuck, wow, we're in El Dorado, please, please do be sure that, look, we've seen this house, we've gone through it, everything is okay, all right? And so you're ready to for the ball to roll, okay?
Yeah.
Because it's always a difficult thing when after after everything is said to be okay, and then we now see an obstacle.
Yeah, once the
Yes.
transaction's been
Yes,
processed, it's hard. It's hard to go back and get the money.
It's very hard to get back and get the money.
Yeah.
And another thing is this. So clients come and say, I'm going to go to court. I'm going to go to court. And I say to them, well, going to court is time plus X.
Yeah.
It is $1 times X. All right. And so you need to also, there is what is called in law contributory negligence. Right? So, okay, fine. The sellers were negligent, right? But you who went and saw, so it's not like it was a transaction done in secret. You who went and saw this thing, what of you, right? So there's a negligent contribution from your part. So you need to think about that. Another thing, Drew, is this. Most times, real estate transactions, so you find a situation where it is said by 12 noon, we're handing over the keys.
Yep.
Right?
Yep.
We're handing over the keys. And then at exactly 11:55, there is a problem.
How often does that happen?
Man, that happens.
Really?
Yeah, that happens, dude. That happens, right? So there's a problem, and you're reaching out to the other lawyer and you're saying, look, this has just happened, right? This thing cannot happen by 12, right? And so the other lawyer then writes back to you and says, well, there will be interest accrued.
Yeah.
There will be interest accruing. I remember one of the deals that we handled, and the opposing counsel, we were sellers, and he represented the buyers, and then this issue came up, right? And so this thing did not close until the next day. So we had to calculate interest per dime, like per day, right?
Yeah.
And put it on all of that. Okay.
Now, just sorry to interrupt, but
Yeah.
when you calculate interest, is it simply just to recover a cost, or is there a penalty associated with it for whoever is holding up the process?
Yes, there are penalties.
Yeah.
But even the penalties is also aimed at recovering some cost.
Gotcha.
Right?
Yeah.
Because I remember one of the transactions that we handled, we were for the purchasers, right? And so there was a problem from the buyers and from the seller's side.
Yeah.
Okay. And my client had packed his things. He came from Saskatoon, packed his things in what's it called? This truck hauling or what are they called? U-Haul.
U-Haul, yeah, okay.
Packed his things, and so what was anticipated was that immediately he came in, well, he's moving, they're giving him the keys at 12, and he's moving in and stuff like that.
So
right?
11:55 rolls around and he now has to sleep in his U-Haul
yes,
truck?
Right. So that became the problem.
An issue, yeah.
Yes, and this didn't materialize until the next day. Yeah. So he had to incur hotel costs and all of that. And so we were letting the opposing counsel know, look at what's happening. right? We sent in the hotel, whatever, the receipts and everything, and we said, look, there needs to be a holdback of this amount,
Yeah.
right? And then let's talk about recouping all that, where luckily the guy said, okay, don't worry about the inconvenience, but money I've spent,
I should be able to have
yeah,
back.
I should
Yeah.
be able
Yeah,
to
that's
have
fair.
it. Yeah. So those are some of the problems that we see in real estate through, and when these issues are happening, it's per minute, per minute, per minute. So you're not even at rest.
Yeah.
I'm telling you, like you are. The other lawyer is writing, you're writing the other lawyers, you're going to your real estate team, what's happening?
There's always a sense of
You're calling
urgency.
the client.
Yeah.
The client, oh wow. It's but when these transactions fall through,
Yeah.
and the client sees how much you have committed to ensuring that his position is protected. I think that essentially that's what Osuji and Smith is about.
Yeah.
Letting the client sees your
the efforts that you've put in.
Your commitment to ensuring that their rights are protected.
So I want to talk about negligence in a moment because I think that's sort of a good lead into another topic. But for a new home buyer or a realtor or even just a regular home buyer, is there certain things that you would advise that they do to prevent these headaches from even occurring?
Okay. So, one of the things, so it's not everything that is in the jurisdiction of the lawyer.
Yeah, so
right?
true.
Yes,
so true.
It's not everything that is in the jurisdiction of the lawyer. So some of these problems are problems that arise outside of the lawyer.
Yeah.
Okay. But again, and I'm not boasting here, but because we're Osuji and Smith.
You boast, man. Boast away.
But because we're Osuji and Smith, right?
Yeah.
What we try to do is we think outside of the box.
Yeah.
Okay? We think outside of the box. So I call the realtor and I sit with the realtor. I say, look, this transaction, what is your forecast about it? Are there any issues likely to arise? These people, have they gotten approval? Have they been financed? Right? Is there any problem going to arise from the finance person? And I call the clients. I say, look, who are you going to for financing? Is there any person we can speak with? All right, and then we call the person. Drew, those are not the lawyer's duties.
No, and that's something part of your practice that you guys just do.
That is what we have developed, Osuji and Smith.
Yeah.
Right? We call the financiers. We say, look, we represent these individuals. Do you people see any problems with this financial thing coming up, right? And then we discuss with them, and they say, well, no, this and this and that, right? And then I go back to the realtor. I say, look, have you seen this house? Have you looked at it? Okay. I call the client again. I say, look, when you are ready to buy this place, do you have anybody who is a professional inspector? Somebody who will go and inspect this property and let us know what the state of this property really is. Do you have such a thing? And then, oh yes, we have this. Or if you don't have, there are people we use.
Yeah.
Right? We can call them. We can arrange with the other lawyer, the realtor on the other side. The inspector can go and look at the place. All right? So we think outside of the box, but we try to as much as possible. And it's not possible to be 100%, right? But if you as much as do 90%, right?
Yeah. Well, I think you're emphasizing that there's a couple of additional steps that can really help to mitigate risk and also provide good service.
Good,
right?
And provide good service, right?
Yeah.
And then prepare everybody's mind.
Yeah, I think preparing everybody's mind is a really good point. I mean, I do doc reviews too, not from a legal perspective, but reviewing of the finance to try and evaluate the quality of the asset, right? And you're absolutely right. There's a lot that you can do, just small bits of information that you can give that really adds a ton of value, or by making a couple extra calls
Good.
really helps
Right.
solve
And
any
Drew,
issues,
let
right?
me tell you one more thing. So when you come to us and when you say, Chuck, I've seen this property and I'd like to buy it.
Yeah.
All right. We get the address, we get the owner's listing. We do what is called a land title search.
Yeah.
We look at, so when we get the land title certificate, we look at encumbrances, registered encumbrances against title. We look at the easements. We look at, are there secondary finances on this thing? Are there lines of credits? Are there home line warranty loans and all of that? We look at all those things. And we call the client and we say, hey, look at this, look at this, look at this, look at this. All right? And well, usually when these transactions take place, the first things that are paid out are all those registered encumbrances.
Yeah.
Right? But you need to bring that to the attention of the client also, so that he doesn't think he's walking into El Dorado. Yes, yeah. He knows that look, there are these problems on this title, right? But we also want to be sure that the individual who wants to pass title to us is the owner.
Yeah.
That it's his name on that document.
Yeah, because you're there's a couple of critical ones, right? Yeah. The one that you mentioned, and then you also, I assume, pull an estoppel certificate, right? That's another critical one, right?
So you want to be sure that the person is the owner, and if you see two names on the title certificate, then you know that perhaps it's husband and wife, perhaps they are co-owners. No marital relationship, maybe two friends who bought a property. All right. So when the documents are coming to you, you need to be sure that those two names are represented on all those documents.
So that's the title. Do you mind just describing a little bit about the importance of the estoppel certificate and then any other relevant documents involved in a real estate transaction?
Yes. So sometimes, these transactions, right? In order to protect both the buyer and the seller, right? There needs to be mechanisms put in place, right, to ensure that, if any warranties, if any promises are made, if there are any agreements, right, protecting the rights of the parties are reached, right, that one of the parties does not now go back, right, on that promise or on that agreement.
Yeah, they're not reneging.
Right. Yes, you can't renege on what you have, right?
Yeah.
And so when an estoppel certificate is issued, it is issued to ensure that, and that certificate will contain terms to the effect that, hey, if you go against this, if any one of you reneges, because Drew, a contract, when people enter into a contract, they have adjusted their positions.
Yes.
Based on a certain set of facts.
Yeah.
So when I've adjusted my position, and then you then adjust yours based on what we have agreed, there must be some safeguards.
Okay.
There must be some provisions that say, well, if this happens, then this is going to happen. Okay. The only problem is that most times people just want to stubbornly stick to their rights.
Okay.
And then it begins to go into litigation.
Yeah.
Drew, for no reason would I accept as a last resort litigation, right?
Yeah.
So people should go into agreements. There's this thing in law: agreements must be kept. acta sunt servanda. That's the Latin phrase. Agreements must be kept. So these estoppel certificates also would help to let you know that, look, we've both adjusted our positions. And in the event that any one of us reneges on this thing, then of course, this is what, is going to happen.
It's going to happen, yeah.
Right.
Are there any other critical documents that create that backup?
Well, most times too, and sometimes in this sale and purchase agreements, right?
Yeah.
There are sections of it, right, that let you know that if and this is one thing we do too, right? When we get these sale contracts or when we get the transaction contracts, we go through it with the clients.
Yeah.
Right. We don't assume. I don't like asking clients, "Have you read this?" I don't like it. I will bring you in, sit you down, and we will go through it together. And then I will show you any penalty clauses.
Because part of your function is to summarize that critical material,
yes.
And they might also be looking at a document that they don't fully understand.
Good,
right?
Good. So you need to explain what these wordings are to them, right? You need to let them know and say, look, hey, this thing says that if you have inspected this place and you don't raise any issues, right, within this number of days, if we sign the documents and money changes hands, if you come back to chalk, then just know that the next thing we are doing is that we are going to court.
Fair enough.
Right?
Yeah.
We are going to court. And one of the things the judge might ask is, were you deceived? Did you were you hoodwinked? Was a gun put to your head? Because you're looking at an adult.
Yeah.
And you're asking, how did you do this? Right? You got into this contract. You signed it. A client came to me some time ago and said that he would like me to go to court to apply to rescind the terms of the contract. And I'm like, okay, is this your signature? Yes. All right. He said he didn't get legal advice. I said, okay, the person you signed it with, did he get legal advice? He said, well, no. I said, all right. So both of you are in the same boat, right? So it's really going to be difficult, except we can prove fraud, deceit, and all of those other items.
So let's talk a little bit about like the deceit and the negligence component of it, right? So so just as a new home buyer, not a first time home buyer, but you're purchasing a property, the issue that you had with the carpet and flooring.
Right.
How does the law define negligence, or how would you as a lawyer go, okay, you know what, someone has a legitimate issue here, or the onus is on the person, or the onus is actually on the person who purchased the property, you should have looked at this. Like is there a fine line?
So Drew, let me say this first of all.
Yeah.
And using my example, all right? In the first place, there was knowledge on the part of the seller that there was that problem.
True. Yeah.
There was knowledge.
Yeah.
Secondly, it was the seller's obligation. The law is that a plaintiff must prove his case and not rely on the weakness of the defense.
Gotcha.
So this guy, the seller, knows, oh, there is a problem. He did not bring it to the attention of the realtor. Again, perhaps the realtor knew too.
Mm-hmm.
Right? He did not bring it to the attention of the realtor. And then they decided that they would take steps to what? To conceal.
Right.
They would take steps to conceal that problem. And they concealed it.
And when you're talking about carpet, like It's not someone threw a rug over, like someone laid carpet down
like
throughout the.
this,
Oh, okay. Oh, so it is something like that.
like that,
They
and
literally.
it wasn't, and even though it was like that, right, it wasn't like stuck to the floor,
Yeah.
right? It wasn't like stuck to the floor, and it was in an inconsequential part of the house. It was in the laundry room,
Ah, okay.
right?
Yeah.
It was in the laundry room, right? So, but I am now telling you about awareness.
Yes. Yes. Yeah.
So it is that awareness component that necessarily leads to the factor of deceit.
Right.
And so the seller knew that there was that problem, did not bring it to the attention of the
Realtor
or maybe
or the
he did,
buyer. Yeah.
or maybe he did, right?
Fair.
Did not also call the buyer's attention to it. So the buyer, you should not then rely on, oh, after all, you went and inspected the house, right? You should ask yourself, first of all, did I know? Was the act of concealment deliberate? And you can't tell me it wasn't deliberate. Because if you had knowledge of a problem and you concealed it, what was your intention?
Yeah, and it's hard. You're hard pressed to have the owner say, "Well, the carpet was there when I
Right,
bought it."
right,
Yeah.
right.
Yeah.
So,
Yeah.
so, so the concept of negligence here is even more on the part of the seller than it is on the part of the buyer. Because first of all, there would not have been a problem if there was no problem.
Yeah.
Now there was a problem, the seller knew there was a problem, hoped that the buyer wouldn't see the problem. I mean, if that's not the highest level of deceit, I don't know.
Don't know what it's. Yeah.
I
Yeah.
don't know what is.
Chuck, you're
Right?
so passionate. I feel like we need to like add a separate thing. We need to create like a spin-off episode of Suits and have our own lawyer
Anytime,
show. Yeah.
Chuck is in. Anytime. I love the public space.
Yeah.
I like letting people know that they shouldn't just sit down and fold their hands.
Yeah.
Okay. I just and that is one thing. That's one of the reasons why I tell you, Drew. That's one of the reasons why I came to Osuji and Smith. You know, and I'm sorry that I keep talking about Charles Osuji.
It's okay. You can plug as you go.
Yes,
Don't worry about it.
but Charles Osuji, all he has done is build this thing, but he lets you be you. He lets you bring your character. He lets you bring your ability to fight, to believe in the strength of your client's case. He lets you bring it into your work. He doesn't hover above it. No, he calls you and says, what do you think?
Freedom within some boundaries, right? Yeah.
Yes.
Yeah.
And that's the good thing about working here. Charles likes people to bring their individualism into the solving of clients' problems. Right? So
okay, so onto clients' problems and back onto the negligence thing. If we now think about or frame that term in the context of condos, townhomes, how do bylaws and how is negligence sort of defined in that arena? Is it the same? Is it different? And I'll give you a good example here. So during the winter seasons, we have there's people that are in buildings that like to sleep with a window open, that then freezes a pipe.
Right.
That as soon as that there's a thaw, the pipe bursts. There's an issue, right? Or people will leave on vacation, and there's an incident that arises from their unit causing damage to others. What determines negligence in those types of cases?
Okay, Drew, let me now that we are talking about condominiums, right?
Yeah.
I would like to draw your attention to 3 documents. The first one is the Condominium Corporation Act.
Yeah.
The second one is the Condominium Corporation Regulation. The third one is the bylaw. Well, a fourth one is rules.
Okay.
So the first 2 are legislations of
the province.
Of the province, right? The third one, the bylaw, is do's and don'ts of the corporation managing the condominium property. The fourth one, rules, are rules that have been promulgated by the board.
Yeah.
So the bylaw is by the corporation. The rules are by the board. Okay? Now, when you apply to have a share in the common factor of the corporation, so it's like shares, right? But they're common factors of the corporation. When you apply and it is approved and you get your mortgage and buy a condominium space, by law, you should be given a bylaw.
Yeah.
You should be given a bylaw. Now, it is not the duty of the board of the corporation to read the bylaw to you. No, it's your duty.
Yeah.
It's your duty to read the bylaw, find out what, because upon that document being handed to you, it's like, on your phones, when you want to get an app or get something, they say agree or not agree.
Yeah. This is your acknowledgement that you will follow those.
And the courts have held that I agree.
Yeah.
Is binding on you.
Yeah.
Okay, good. So when the bylaw is handed to you, that is your I agree. You cannot come later and say, oh, I didn't know this was provided in it. All right? They should not even tell you go and seek legal advice. It's not you people are not in contention. So when you get the bylaws provide for, there is a corporation, a condominium corporation that I'm reviewing their bylaw right now.
Okay.
And one of the things I've put in there is that this bylaw being given to you is your consent to and your acknowledgement of having read, having understood, and having agreed to be bound by the bylaws. So in these bylaws, there are provisions for, so some of the bylaws refer to rules. So the rules would then say, perhaps if you're living in winter, do this, do that. If this is, setting out how to take care of common properties.
Right.
Under the Condominium Property Act 2, there is a provision for the board, for the condominium corporation to levy
fines.
Thank you.
Yep.
To levy fines, right? Yep. There is also a provision for the condominium corporation to, meet and take decisions affecting any unit, right? So if your unit, if the way you have lived in your unit has led to the damages of common property, right? Yep. So whatever is in your unit is your property.
Yep.
But if there is a line, a sewer line running wherever, and as a result of you keeping whatever open, the sewer line bursts, that is on you. You have to repair it. You have to make sure that, so the condominium corporation would then be on you. And then again, that imports the concept of negligence, right? Because, if you, Drew, we live in Canada, okay? Yep. And except if I came in today as an immigrant, if I came in today in winter, I would not be knowledgeable about the effect of winter and all that. I remember when I came to Canada in March of 2013.
Okay.
And I was dressed.
Caught the tail end.
No, I was dressed like you.
Yeah.
I was dressed like you. I hadn't been in snow before or whatever. So I just took my bags and walked out of the airport. and then the cold enveloped me. Oh my God, I ran back. No, I ran. I'm sorry, but
I like the cold enveloping me. This is a cold day outside, and
yes,
this is me.
I
So
ran back
yeah,
into the airport. So
yeah,
except you say,
yeah,
"Oh, I'm just an immigrant who is coming now," I don't know. You know, there is general knowledge about what happens in winter,
yes,
about the effect of winter on materials, on things, right? So what you've done is not wear and tear.
that's correct.
It's not. It's that you've deliberately done something to damage, right? So that is negligence. That is negligence on your part for which you should pay.
And is so is what you're saying that the bylaws at least have to acknowledge or define what was is negligence, or is that already
No,
defined in?
that's defined in other legislation, for example,
Gotcha.
right?
Yeah.
But that definition would properly suit the action that the individual has done.
Right. And just on the thought of common property
Yeah.
damage, that doesn't have to be a physical damage. Someone like the condo corporation could suffer a just a fiscal loss in something. So there's a good example that that I had arise a while back, and that was one of utility costs. So it's a smaller property, and utility costs for are paid for by the condo fees, right? But an individual in one unit had a running toilet. It never stopped
Okay.
for a period of time. Ended up tripling the condo fee, the utility cost for that property.
Okay.
Is that something that the board could consider as negligent and or like a common property damage?
Okay. So let's segmentalize this issue now, right?
Love it. Let's do it.
Good. So um, first of all, the toilet is in its unit.
Yeah.
Right? And there are some condominium corporations that have a way of, so they have meters, for example, that register the usage of water, right? So the water coming into the condominium is general water, right? But the water going to each unit
Yep.
now becomes the property of that unit, right? So if this unit had used in excess, okay, the meter that is set up against that unit should then be able to show that this individual has used water to that excess amount. And so sometimes when utility bills come out for these units,
Yeah.
like for example water, it should register against that unit. It should not, so if for example the water for the entire building is for example 10 liters, and this individual has used 2 liters as a result of his running toilet, okay, then that meter should show that the 2 liters was used by this place and not by Drew's or any other person's apartment, right?
Yeah.
It should show, okay? So when things come into the corporation, it is common. But when it goes directly to any unit, it then becomes the property of that unit,
Right.
for which that unit owner should pay.
Okay.
Yeah.
I guess more of a challenging issue if the property is built with a single meter.
Well, if the
Right.
property is built with a single meter, right?
Yeah.
Then if the corporation notices that the excuse me, if the corporation sees that, oh, we are going above these 10 liters that we've been right, they begin to trace and say, oh, what's this, what has happened, the cause of it, right? And they find out that a unit has used, right, it has a faulty toilet and all of that, right? It is their right to call their attention, okay, and then to to then say, okay, because of this and that, right? This is what you're going to pay in addition.
Right. Okay.
This is what you're going to pay in addition. And you know, it's
And so that unit owner doesn't have a good position, or is probably not correct if they say, well, I pay utility costs, this is just my utility cost.
No. You see, you are also bound not only by the bylaws, but the act and the regulation,
Okay.
to ensure that the private properties consisted in your unit are functioning properly.
Gotcha.
And not to let it fall into disrepair in such a way that it begins to affect the rights of the other people.
Yeah.
You understand?
I understand. Yeah.
In such a way that you begin to, so he can't say, oh, you know, this is in my property. Well, it's in your property, but what's happening in your property is now beginning to go outside.
Yeah.
Right? To affect the quiet and peaceable enjoyment of others of their own rights. Right?
Okay.
Yeah. And again, let me say this. Under the law, under the Condominium Corporation Act, if the corporation levies you and you don't pay it, in a general meeting or in a meeting convened for you guys to vote,
yeah,
if you haven't paid that thing 60 days prior to that meeting, you will not vote. If you send a proxy, the proxy will not vote.
So you've sort of you've lost your power.
You've lost your power to vote.
Yeah, to vote.
Yeah, to vote.
Yeah. Still have other powers.
You can attend, but you won't vote.
Yeah. Okay. Just on this general theme.
Yeah.
What then about and we're talking about disclosure, negligence. What about documentation? If we could just maybe circle back to that a little bit again. So when you go to purchase a property, there's a list of documents that you can obviously request to have reviewed and looked at, right? That a prospective buyer can have looked at. What, but at times there is not a formal or complete document. So something might be in a draft form or not approved by the condo board. What obligation do they have, or does the condo management company have, to divulge that information or provide that information if it's not formalized?
Well, so let me take a bylaw for example.
Sure. Yeah.
Let's take a bylaw. It is the prerogative of the board to vote amongst themselves for the bylaw to be amended, for it to be repealed. So that's personal. That's the board, right?
Yeah.
After that, if there is, like the bylaws I'm amending now, right, for a certain board, right? After this amendment, I send it to the board, and then the board reviews it. They point out this, point out that, point out this. They send me their questions. I have a meeting with the board, and then I explain. I say to them, oh, section these of the Condominium Corporations Act did that, right? And so in all of that back and forth, it has nothing to do with the owners.
Okay.
In all of that back and forth, it has nothing to do with the owners. Now, the condominium board and I agree, finally, is a document is brought out. You see, at the stage of all of that drafting, you can't give it to an owner.
Yeah.
No, you can't. Right? At the stage of all of that drafting. When it is ready, and the board sees it is ready, the board can then call a special meeting.
Okay.
Now, before that meeting is called, this document, drafted by Chuck, agreed to by the board, is sent to all the owners. And then, when that document is sent to the owners, the owners will be told, oh, we've amended the bylaws. This is a copy of the amended bylaws. It hasn't become legal yet. It will only become legal when it is passed in a meeting called for that purpose, and it will be by special resolution of the members. Now, and I will tell you the significant thing here. The difference between special resolution and ordinary resolution
Yep.
is that in an ordinary resolution, majority of people present passes something.
Okay.
In a special resolution, when it comes to the bylaw, 75% of the people present must vote to pass that bylaw.
Well, it's not just people present though, right? It's 75% present or not.
No, so when you're voting, well, you know, the law provides that you can vote by electronic means.
Yes, yeah.
The law also provides that those calling in or on camera are deemed to be present.
Right, but when you go to pass a set of bylaws, if you hold like a town hall to have them passed,
Yeah.
right, and that gives everybody an availability to be there. If 75% of the people that are in the room and or on phone or that via Zoom, let's say,
Right.
if that doesn't constitute 75% of the total unit factors in the total building, those bylaws can't be passed.
That's not true.
No?
No, that's not true. You see, I can send you a notice to attend a meeting.
Okay.
I can't compel you to come. I can't also compel you to send a proxy. All right?
Yep.
So the law considers these things. So the law says 75% of those present, not 75% of the unit owners.
But bylaws say that, and so does the act.
Any bylaw that provides that, and you see, this is where the lawyers come in.
Okay.
This is where the lawyers come in. Any bylaw that provides that, any bylaw that is inconsistent with the terms of either the act or the regulation is void. Any bylaw, the terms, if there is a section 35 in the bylaw and it is inconsistent with any of the terms of the act or the resolution, it is void. If the condominium corporation, if the board makes a rule, you know, I had defined rule, this act, regulation, bylaw, rule. If the board makes a rule that is inconsistent with the bylaw, the rule is void. If the corporation makes a bylaw that is inconsistent with the act or the regulation, the bylaw is void. So any bylaw that says that the entire unit members must be present, that bylaw is void. Why? Because the law, the Condominium Property Act, says 75%. It is well defined.
It's 75. It's well defined as 75% total unit factors and total percentage.
75% of those present and voting. Okay. 75% of those present.
Chuck, we may have opened up a Pandora's box here. I'm gonna want to know this one a little bit more and dig into it.
I wish Joshua.
No, it's okay. It's okay.
No, I could just get the law for you and read it out directly.
Sure. Well, okay. Well, we'll move on. But yes, I am so curious about this one now. Sure. So curious. How about for new homes that are built and new condos and warranty-related issues? Have you ever dealt with concerns or any litigation around new warranty or warrantable issues?
Now, Incidentally, there is this legislation that it's called the New Home Warranty Act.
Mm-hmm.
All right, so it provides for incidences or things that those who are buying new homes, right, are entitled to. So there are some warranties, right, that come with, the fact that somebody is a new home buyer, and I go back to that example of me buying a home, and right. So um, under the new home warranty, the new home buyers warranty act, right? Things like that will be talked about.
Yeah.
That you don't deliberately deceive somebody who is a new home buyer. There are warranties. There are sections that speak to one, you are assuring this new home buyer that you have the legal capacity and the legal right to do what you are doing. You are assuring this new home buyer that, look, when I say this house has this number of columns or that number of that is what it has. You are assuring this new home buyer that this wall that I've set up is built to last 15 years.
Yeah, okay.
Right? And stuff like that. So there are assurances in that act for which, if it is discovered that those assurances are not true, then there are penalties.
Yeah.
Okay, there are penalties. Okay, so when a new home buyer is coming to present himself, to enter into a transaction with you need to know that you, as the person, the condominium, well, first of all, let's even take a situation where, well, the land has been acquired.
Okay.
The developer starts to develop, right? And when the developer registers the plan with the land titles, the registrar of land titles, right? The developer is meant to constitute an interim board. That board will be changed after the place has been developed, okay, and they have a bylaw, and the bylaw is registered, okay. That board will be changed after that, because then they have to hold what is called an annual general meeting. All right, that board will be registered. So when the developer is developing, and after developing, people begin to come to show interest in that condominium property, right?
Mm-hmm.
The developer is under an obligation, full disclosure, Drew, under an obligation to let you know the specifics of this thing. This is how we've built it. These are the materials that we've used. In essence, he is guaranteeing that, look, I have built this thing to Canadian, what's that word? I'm sorry. To Canadian building standards.
To code.
Yes.
Yeah.
To code.
Yeah.
Right? I've built it to code. All the materials I've used. Because, man, if I buy a condominium property and within 2 weeks, right, the wires are burning up inside this thing.
Yeah.
Right? I mean, and the problem here is, at the end of the day, you might have to go to court to protect your rights, right?
Yeah.
But there is a legislation that protects you as a new home buyer. There is a legislation that protects you as a new home buyer. Okay.
Okay.
Yeah.
Perfect. Why don't we take a break there for a little bit, everyone can have it. And if you need to swap in, do some questions. Is that good?
Oh, sure.
Sweet. We'll just do that for like
Okay.
2 minutes.
Let me go get that.
1 second. Okay, so we're recording. Okay, I'm looking at the cameras this time because